Well, let's talk about the family. Family is so critical to everyone, be it for emotional support, monetary support, love, all of those things. How does the Truett Law Firm intervene with respect to family services and family needs?
There are a number of things that we can offer to a family, so it's not all bad. Sometimes people think of the divorce or the custody battle, but there are adoptions that people want. There are guardianships that people need, especially over grandchildren, especially when you need to have them in a certain school district and things of that nature. There are guardianships that happen with children because maybe their parents aren't ready at that moment to take care of them. So we do those things, but we also do dissolutions of marriage, commonly known as a divorce. We also deal with child custody, and it's not always negative. Sometimes it's just a matter of seeing things in a way that is good for that child and that family and helping them come up with that solution that works for them.
I have to wonder today with COVID, we may find a child parentless as a result of the illness and the parents transitioning. What happens in that situation?
Normally, what happens in most states, and Missouri is included in that, is that the other parent is considered to be the parent of that child. And so that child will go with that parent. What has happened, though, is that some parents believe, depending on the other family's lifestyle and how they live in this kind of an environment, that pushing a child between the two, so in an environment that is more protected and away from COVID and closely observes the tenets that come along with COVID, such as hand washing and social distancing, to a family that does not do that, puts the child at risk. And so sometimes you have to go to court and have some intervention in those kinds of situations. And that's all new because of COVID. If you're a healthcare worker, for example, you are working longer hours. And is it fair then to have the child with another relative when they could be with the other parent? So that has come up because of COVID. And then when you're working in COVID, are you putting the kid at risk because you're a healthcare worker, for example, and you may transmit that to the child? And you could be a physician, but there's a higher risk if that's your population. And is it fair to have the child in a situation like that? So those are all new as it relates to COVID and some of the things that are happening now.
Visitation rights. I mean, when would that become a necessary scenario for a family?
Sometimes when parents can't agree, they have to go to court and have something in place to enforce and to allow visitation. So when you have parents who can't agree on when the child is to be seen and under what circumstances, then you go to court and you make sure that both parents get a good chance at seeing the children and participating in raising them.
You described a scenario where the woman was not very honest in her description of what the problems are in their relationship. And it has caused the male, the husband, the father, to go back to court repeatedly to address the complaints that she continues to levy. How long does a paternity issue carry on?
So a paternity issue is a shorter issue, and so what happens in those kind of situations are that you're trying to declare who the father of the child actually is, and that's necessary because if a person is asking for rights to see the child, he should probably be declared the father of the child before they go to court. In situations where you have parents who both love their children, and they are not together, which means that they may love their children in two different ways, and they express that love for their children in different ways. And sometimes those ways are destructive to each other, to the parents, while trying to maintain a relationship with the children. And sometimes it has an impact on the children, and sometimes it doesn't. It has a lesser of an impact on the children. But what happens in those kinds of situations are that parents need to realize what's going on for their children and do the best that they know how. And sometimes court have to help with that. So we don't always know the best way to help a parent until they come in and we help those parents. And sometimes that is as advocating for a visitation schedule that's more reasonable given the circumstances that are in place at that time. So sometimes when you initially make the visitation schedule, you're dealing with a 3-year-old. Now the child is 11 and wants to go and be with their friends who happen to be all at one parent's house. So this child no longer wants to go over to the other parent's house because the friends are over with one parent. So now the child doesn't want to go, but it has nothing to do with what the parent did. It has to do with the child has friends now.
Okay.
And so those things have to change. Sometimes parents are in toxic relationships with each other or invite toxicity in those relationships. I find that in my practice, you either have intensity or duration. It will either be a very long time and it won't burn as bright, or it will burn really, really intensely at first, but they can't go for longer periods of time. And so once you sit down and see what kind of client you have and what the issue is, it's helpful to a court and to a client to understand and appreciate what the parameters are and what is possible and then what is probable.
Maybe I'm misunderstanding. That man you were speaking about in Illinois, is that a divorce? Was that a divorce case?
They are already divorced. She wants to move she wants to move out of the state.
And there's a child involved.
There are 2 kids involved, so yeah.
So now that's why you have been hired to help address that situation, keeping the children in state or visitation out of state?
So sometimes when parents don't agree and they've been divorced, and this happens a lot, they change because that's part of the reason they got divorced. They are no longer a union, and so they have changed. And sometimes parents do things to advance or get an advantage so that they can have something that makes sense to them. It may not make sense as it relates to the children, and it may not make sense as it relates to co-parenting, but it may make sense to them. And people, being people, they do what they believe makes the best sense for them at that time. And you go to court to help make a determination as to what makes sense given all of the parameters instead of just one person.
Order of protection.
Sometimes people need to seek an order of protection, and that protects them from abuse from another person. Sometimes they are used correctly and sometimes they're not. Sometimes they're used as a tool to get an advantage. When that happens, you need a lawyer to effectively differentiate for a court the facts of your case. And those are the things that I know how to do.
That makes me wonder about prenuptial agreements and premarital agreements. Some of those things probably should be addressed so that you don't get to the point where you're dealing with orders of protection and keep the person away from me. Explain how your firm addresses the situation before marriage.
So normally a prenuptial agreement talks about what would happen in case of a divorce. And a lot of people don't get them, but for 2 reasons. They either feel as if they don't have anything to protect, or they feel like they're planning for divorce. In reality, what you're doing are planning the terms of an exit. It's much like any other contract. If we are not together, these are the things that we need to do. So it talks about, this is the property that I brought in, for example, and it's the property that I want to bring out. So it talks about how those things are to happen. What happens if we have children and how they're going to be supported in the event that we are no longer a married couple, a unit together. Doesn't mean we cannot co-parent. It deals a lot with assets, and it deals a lot with decisions. So for example, if we are no longer a unit and we are of 2 different religions, we're going to agree in advance that we're going to raise our children in this religion, so that if anything happens, because this is maybe important to one person, so we can agree that if anything happens, there's no ambiguity on the decisions for our child, because we made that when we had a cool moment to reflect and made the decision as it relates to our child when things were good, not as a reaction to the current circumstances.
Family mediation, what is that?
Sometimes families don't get along, and sometimes they want to. Sometimes it makes sense to have a third party to listen to what's going on and come up with a mediated agreement. Sometimes people do mediated divorces. In other words, We're going to agree to everything that happens, but maybe we can't agree together. So you go to a mediator and you work through everything and draft everything. But in that case, it's less expensive. You get what you want. When you can agree on something, you're likely to get more of what you want in a family law situation than when you don't agree. Because if the court has to decide, that means they're going to balance everything. And that means that they're going to look and see. But you may agree on something different because it makes sense to you.
Is it always necessary to go to court when dealing with family matters?
It's not always necessary. I think it depends on what it is you want to do. If you want it to be permanent, you're going to have to go to court. But a lot of times court is not all that scary. It's the emotion that people bring to court. When I work with cases, I try to be really cool and reflective because I need you to be okay with this 10 years from now so that you maintain your identity, your dignity, and the respect that you had going in. And I want you to be able to maintain those things. So I work in a way that helps to do that. And I manage expectations of people with the result, and I manage their expectations with the probability according to what the law says is going to happen. So a good example is there used to be a situation in Missouri where fathers didn't get as many rights as they have now. So it used to be a split situation where you got every other weekend and one night a week. Fathers currently in the state of Missouri presumed to get 50-50 custody now. That's a big change for some people. That's a big change for some of the fathers. Because now you can actually be a viable part of your child's life and work and travel, and you're going to have to manage that expectation. So we talk to people, and not just fathers, mothers. So when you have a situation where, for instance, she is a stewardess or she is a pilot and she travels back and forth for a living, that is how she makes her living, she can now find ways to be in her child's life and continue the life that she knows, the income that she receives, the education and training for which she is fit as well. So it works both ways, that there's not a situation in which the presumption is one parent should have more time. Now it's both parents should have equal time unless you tell me why that should not happen. It's a big change for people. So you have to help people understand what the responsibility, that's a wonderful privilege, but there's a big responsibility that goes with that. So if you have the child 2 days a week or 3 days a week and it's a school night, you have to do homework with them now because I can't. And you're going to have to get them to school on time, every time, on time, and they need to eat. And so it's not a situation where any parent's going to spend 2 or 3 hours and then take them back. You're going to parent now. And for some people, that has been an amazing transformation. And I try to make that so that it's an amazing opportunity for all parents.
How does the Truett law firm engage two people when child support is an issue?
In the state of Missouri, child support is figured by a Supreme Court rule under Form 14. It's a formula. It is that simple. What can happen is you have to know the right amounts to put in certain places and the right questions to ask. So, for example, if the kid is in private school, that may be an expense that's on some that are not on others. If the child has disabilities or has increased ability so that they're in a gifted program that requires extra income for them, they're on particular sports teams and things of that nature. Those are things that can be considered for child support purposes, especially if the child is well adjusted. So if you are 15 and you've been in a private school all of your life, you're probably going to need to consider child support to keep that child in that placement kind of a thing, because that's the only thing the child knows. And so it becomes expensive when the parents aren't together because they're just a division of resources. When people aren't together, especially after they get a divorce, when they've been sharing everything. And so we have one house payment, not two. You have one light bill, not two. When you split, you have a double of everything, and you still have to take care of the child. So what we do is advocate for the right amounts to be placed in the right places. And we ask those questions. Child support is a formula in the state of Missouri.
Well, now, does the state of Missouri favor the woman over the man in a situation like that?
It does not. That's a common misconception. It favors the placement of the child and the stability of the child. Where the child is normally with the father, then it favors things to stay as they are because the child should not adjust around the parents. Rather, the parents need to adjust around the child. But there's no favor of one parent over the other.
What if things change over time? At 10 years old, the circumstances were A. By the time the child is 14, circumstances have changed and now it's B. Do we have to go back to court?
You can file the paperwork, certainly, but that's called a motion to modify. And it's just a continuing change in circumstance, such that maybe the child is not, needs to do better at a different school district. And so in order to get the school district in which the other parent lives, because now they've moved to a different school district that is better, the court paperwork has to change to reflect that. Those are really easy to file in some cases where there's not a lot of emotion involved, that these are just facts. When the parents don't agree on the circumstances, and certainly when they don't agree on the solution, then you do have more involvement with the court, but there's still usually a good solution for both parents. They may not like the solution, and it is easier if they agree. But there are opportunities for them to file a motion to modify, and we do those kinds of things. Look at the entirety of the circumstances to determine what's best for you. What's best for you? Because sometimes filing a motion to modify feels good, but it may not be what's best for the person who's going to file it, nor is it best for the child. But it may make them feel better for whatever they're going through at that time. And we've successfully been able to show people what the better thing is for them in the long term. Do you want to do this now, or is it better to do this later when, for instance, you get the promotion you're trying to get, or when your sisters move closer to you so that you have support?
So the Truett Law Firm is committed to helping families maintain good relations, whether they're together or they separate.
We are committed to helping all families and maintaining those relationships for the good of everyone involved.